Former police officer, prosecutor, now attorney in private practice, Pete Schulte is in. You've seen him before. He talks with us on legal matters. He may talk about us when we're not around.
Right.
All right, Pete, thanks for coming in.
Absolutely. Thanks for having me.
Everybody's been watching this case.
Right.
Was the verdict today a surprise to you?
It was not. Back in the day when this happened about a year and a half ago, you know, as we talked about, I think you even talked about on Fox back then, it was the evening after daylight saving time had ended, so it was still light out.
It was light.
There's a defense in the penal code with somebody who's committing theft in the nighttime, you can use deadly force. However, back then when we looked at this and so was this an officer-involved shooting? And what we kind of came back to is that this was not an officer-involved shooting. This Mr. Johnson was not in uniform. He was not acting as a police officer. He just was a citizen or civilian who happened to be employed as a police officer got into a shooting. And I think that's what the Addison Police Department, when they investigated, had to focus on.
So you not only think it was not a surprise, you think it was the right verdict also?
Under the facts,
yeah.
And I look back as when I trained at the academy to the new recruits, and we talk about use of force and what's justified. A lot of people forget about that nighttime, and I don't know, and I'm not going to speak, and put words in Ken Johnson's mouth.
Sure.
But maybe he felt like he was justified because of a misunderstanding in the law. But you know what? Ignorance of the law is no excuse.
I don't know if he had time to even think about that.
Right.
We'll never know. All right, Ken Johnson did not testify.
Not surprising.
Not surprising that the accused didn't testify.
Correct.
But the defense didn't call a single witness. In hindsight, do you think that was a mistake based on the verdict?
No, and I'll tell you, the murder cases that I've tried and won, I haven't called a single witness as a defense because remember, the state of Texas has the burden of proof. They have to prove each and every element beyond a reasonable doubt. That's greater than clear and convincing evidence. So if the state's doing their thing, and I kind of say even jury selection, if I don't call any witnesses, that means I think the state didn't do their job. So in a lot of cases, even in murder cases, the defense in guilt and innocence, because Texas, we have a bifurcated trial process, which means the first phase is guilt and innocence, which we found out today that was a guilty verdict. Now we're moving to a sentencing phase, which is a sentencing trial, which is important in this case.
Okay, you say you didn't call any witnesses, but the prosecution had some powerful testimony this week from eyewitnesses. I want you to listen to that at home, and then you can gauge the words, the effect they had in the trial.
He said something to the effect of, "Man, I'm tired of this. They stole my stuff." And then shot again, about another 4 or 5 rounds. And then I was like, "I'm calling the police." And he said, "That's okay, I am the police."
He's yelling at him, pointing a gun over his head, clicking, but there are no more bullets.
All right, so does eyewitness testimony help when there are so many eyewitnesses saying the same type of thing?
Yes, because I'll tell you, these people, these eyewitnesses, did not choose to be where they were to witness this incident. So when I was a prosecutor, I used to bring witnesses in. They don't have a dog in the fight. They were brought in because they're eyewitnesses. They're just telling what happened. They don't have a victim that's a relative. They don't have anything to do with it. They're not related to the suspects. Right. That is the most powerful testimony the state can bring in cases like this, and it worked.
Okay, let's talk about sentencing. January 8th, we've talked about it coming up. It'll start. You think the defense will use a defense, or I guess a thing that can diminish the sentencing that's called sudden passion?
Yes.
You think they will?
And
how will they use it?
And I'll tell you, so basically what sudden passion is that murder is a first-degree offense, right? First-degree felony offense. So if in the sentencing part of the trial, so it's a whole trial, which I think is why Judge White pushed it to January 8th, it's because it's going to be lengthy. If they show that the defendant acted because of sudden passion, I think it was set up from the very beginning by the defense that he was really angry, he wasn't thinking straight, and that by its definition is sudden passion.
It's interesting, I think the prosecution played to that because the witnesses seem to show a guy out of his mind almost.
Right.
If you believe that he was still pointing the gun, pulling the trigger when no bullets were in it, and that he yelled, "I am the police," and he then returned to firing, that seems like someone not
thinking straight,
full capacity.
And it's funny that you bring that up because I think that the state had to take the position: are we going to treat him as an officer who got into a shooting, or are we going to treat him as a civilian who got into a shooting? And I think they chose to treat him as a civilian because the aggravated assault, if they had said it was by a public servant acting under the color of his office, and they probably could have gotten there with the witness saying that this is the police, I am the police, but they didn't. They charged it regular aggravated assault with a deadly weapon, which is a second degree. So if the jury believes, and it's only by the preponderance of the evidence, I know it's a legal term, but that's less than beyond a reasonable doubt. If the defense can prove by the preponderance of the evidence that he acted because of sudden passion, it reduces the penalty range from a first degree to a second
So I'm
degree.
going to ask you 10 seconds. Can you give me the parameters?
The parameters
Sentencing?
are, yeah, so now if they believe that, then they're going to do another fact of the jury verdict is it's 2 to 20. So both charges, aggravated assault with a deadly weapon, that's already a second degree. If they find sudden passion with the murder, the maximum prison sentence for him will be 20 years. And he's not eligible for probation because he was convicted of murder. And that is it's game over on that. So he can't get probation. So the jury's going to have to decide, was there sudden passion? If there was, then we're looking at 2 to 20. If not, then go anywhere from 5 to 99 or life.
Got it. Pete Schulte, thank you very much.
Absolutely.
Heather.